Welcome, everyone. We are here for the California Advancing PREA office hours, especially focused on supporting incarcerated survivors through the grievance and legal processes. And I'm going to go ahead and hand it over to Edward to talk about the agenda for today.
Sure. Thanks, Marcela. Yeah, so we're going to do some brief introductions, talk about Valor, JDI, though you guys know us well, I think. I see many names that I'm familiar with. It's good to see everybody. And yeah, so today we have two guests. So during our regular check-in calls with advocates, there's a lot of questions that come up about the grievance process. There's questions about how long somebody should wait for a response, how to support people through that process, because I think we as advocates aren't as familiar with the details of, how somebody would file the grievance and like what the whole process looks like from beginning to end. And then we also get a lot of questions about legal stuff. So as we know, survivors will often ask us for help in filing a lawsuit or finding legal resources. And while it's not necessary for us to know all of that, I think that there is a role that we can play in supporting people as they advocate for themselves and as they move through the process. So since we get so many questions about the grievance and legal process, we decided that we would ask some people who have actually lived it, experienced it, navigated it successfully to come and share with us a little bit. So we have Johanna Mills, who is a staff member at JDI and has a lot of experience in CDCR. So she'll walk us through what the process looks like for the California state system. We also have Jonas Caballero. I've never actually asked you, Jonas, how to pronounce it, but he successfully navigated also the grievance process and the legal process, and has had some success in filing lawsuits in New York. So Jonas will share a little bit of his experience as well. And we also want to leave a lot of time for questions and answers. So please, as Johanna and Jonas give their talks, feel free to enter questions in the chat. Or save them from the end. We definitely want to leave a lot of time for that because we know that people have specific questions. So we want to be able to have those answered for you. And then we have some resources that we're going to share at the end, some links, and then some PDFs that we'll be able to share after our office hours today. Marcela and Jenica, I think I'll ask you guys to introduce yourselves.
Absolutely. So, as you can see today, Edward is manning the ship today, but we are around. So I'm Marcela Rojas Salas. I use she, her pronouns, and I'm one of the project managers here at Valor US. And we work closely with Edward at Just Attention International. I hand it over to Jenica.
Hi, folks. My name is Jenica Sinor. My pronouns are she, her, and hers. I'm a project coordinator here at Valor US. Yeah, really excited to be here. I want to thank Johanna and Jonas. We'll go over some housekeeping stuff and a little bit about Valor and JDI, and then we'll get to it.
And I'm Edward. I think I know most of you. So do y'all want to do the housekeeping stuff?
Yes, sorry. We've all been using Zoom for a little bit, but if you have any questions, feel free to message me or Marcella if you're having issues with audio or anything. If you need to call in, you can do that as well. You can feel free to use the chat if you have questions or if something like really resonates with you. Feel free to do that. And then next slide. And then a little bit about Valor US. Valor US, formerly the California Coalition Against Sexual Assault, is committed to preventing and ending sexual violence by advancing equity and eradicating oppression. So what that means is we provide leadership, vision, and resources to rape crisis centers, individuals, and other entities committed to ending sexual violence. Ultimately, what we do envision is a world free from violence, where the dignity of every person is valued and respected. And then a little bit about the California Advancing PREA project. Now, in its 8th year, the California Office of Emergency Services, or CalOES, has funded this project, the California Advancing PREA project, and it allows Valor and JDI to partner in offering support and guidance to California rape crisis centers and on how to build strong relationships with CDCR, county jails, and juvenile facility staff. We work together to provide guidance on how to create sustainable agreements for the provision of victim services to survivors. And although we've made a lot of progress, and you all have made so much progress, we understand that there continues to be a gap and a lot of challenges that are faced in the services available to survivors behind bars. And I'll turn it back over to Edward for JDI.
Yeah, so JDI is a health and human rights organization that seeks to end sexual abuse in all forms of detention. We do that work by partnering with departments of corrections. So we provide guidance, training, coaching to departments of corrections and helping them implement policies that keep people safe. And then we also work on the other side, working with rape crisis agencies to do the same, to help advocates understand a little bit about the correction setting and what incarcerated survivors might need. All of our work is sort of built around this principle that no matter what crime a person may have committed, rape is never part of the penalty. All right, so our first speaker today is Johanna. Can you all see that? So Johanna is a program associate at JDI and a longtime member of the JDI Survivor Council. Johanna has been at the forefront of the fight to ensure the dignity of incarcerated people. While she was incarcerated, Johanna worked closely with JDI on pushing for many key initiatives, including the Prison Rape Elimination Act. Johanna was released from prison in 2019 and has just done an amazing job of rebuilding her life. I'm lucky to call her a friend, and I got to visit Johanna when she was still incarcerated to get input for the standards before they were released. So Johanna was a really key part of that. So Johanna, I'm gonna go ahead and basically just let you have the floor a little bit. If you could walk us through, and in particular, so since we're focusing on the grievance process today, if you could walk us through what that looks like in CDCR, like from point A to point wherever we need to get to. If you could share a little bit about your own experience. And then also just generally, because I think people ask us questions, not just about sexual assault grievances, but also, if they've lost their property or they're not getting the medical care that they need. So yeah, if you could just talk a little bit about or not a little bit, but if you could tell us about the process.
Sure. Thank you, everybody, for being here. I've had lots of experience with grievances, and in the state of California, they're called grievances or appeals. So you will see a lot of times that's written or spoke about as either one of those. They mean the same thing in CDCR. So things that you can appeal in prison are policy, decisions, actions, conditions of confinement, omission by the DOC or its staff that has or can demonstrate having an adverse effect upon health, safety, and welfare. So I think it's really important that you know that while you're in the system or once you've been released, as long as you're on parole, this is available to you. You can still get those forms from the parole department, and you can still grieve any of those issues that you're having, even though you have paroled. So there's 3 different levels. There's an informal, there's a first level and a second level, which gives you 3 levels. And what the Department of Corrections actually likes you to do is try to resolve something by actually having a conversation, maybe with the person, the staff member, or whatever department that you're having this issue with. They like for you to have a conversation with them about it first to try to resolve it on its lowest level. In most situations, it's usually boils down to a staff inmate issue or a staff parole officer issue. And this is not something that you want to go maybe and talk to them about. So they do have something called an inmate request. Now you can send that inmate request to this individual or to this department and try to get your answer and get it resolved this way. And basically why you would send an inmate request is to keep a paper trail. You really want to keep a paper trail of everything that you do and everything that you have done in regards to the issue that you're having. So then if you can't resolve it on any of those levels, you want to go with the informal level. Now the informal level is actually going to be turned in and go to the appeals coordinator, who's going to then in turn turn it around and send it back to the person that you're having the issue with, or the head of the department that you're having the issue with. They're going to try to do a little research, hopefully, and give you an answer to your informal grievance. There are time frames for these grievances. And so,
Johanna, can I stop you and ask a question though?
yes.
So if it is a case of sexual assault, it would go back to the person that you're.
No, never. That would be an emergency grievance. And those, the emergency grievance goes directly to a staff member who you would go to. Depending on who the sexual assault would be, like if this is somebody in your unit, you're obviously going to go to the sergeant's office and try to speak to a lieutenant or a captain. Emergency grievances go directly to the lieutenant or captain, which is handed directly to the appeals coordinator, which is going to be sent directly to, let me see here. It's going to be sent to the Office of Internal Affairs. Nothing that has to do with any kind of staff related incident in that type of incident is ever going to be held in that facility, ever. It has to go out to the Office of Internal Affairs. It also it's a mandatory, it's mandatory that it's also reported to, to the director of like the hiring director. And so everybody on the highest level would know about this. These things have to be resolved immediately. That person would be removed from direct contact with inmates right off the top. They would either, it depends on I guess, the significance of the assault. Like if it was an actual sexual assault, they're going to be taken completely out of the facility and then dealt with in a different kind of way. And oftentimes, unfortunately, they're just sent to other facilities. If it is something like sexual harassment, same thing is going to happen, but the staff member may be just placed in the mailroom, which they have no contact with inmates in the mailroom. That's a place where inmates aren't allowed to go. And so sometimes they're just placed there. But
Are there timelines? Like,
there are definitely timelines. Some of these grievances, depending on what they are 30 days, 30 calendar days, or working days. It just depends on the type of grievance. Now, calendar days means weekends count. Working days means they're talking about the 5 work days in a week. So basically a 30-day, when they say 30 days, 30 working days, you're actually looking at more like 6 weeks. So, which is kind of misleading if you're unaware of what that means. So there's definitely, everyone should have equal access, disabilities, language barriers, etc. You can only file a grievance every 14 days unless it is an emergency grievance. And it's calendar days, and which means weekends do count. You can only put 1 issue per grievance. If you include other issues, it will be turned around and given back to you to rewrite, or it may just be completely, found to be unsuitable altogether, and you cannot re-grieve the issue. So it just depends on who hears it. there's different levels of that. Some of them go to sergeants, some of them go to lieutenants, others go to captains. It just depends on what your grievance issue is about. Different types of emergency grievances are involuntary psychiatric transfers is one. It may be a medical issue, or it could be a safety issue. But even in those categories, they have 5 days, which to me is way too many if you're having a safety issue or a medical issue. I mean, and they will tell you, are you bleeding? Because if you're not, then this is going to be 5 days. And so, and some of the rules of construction are very helpful too. If you know what you really need to know what the rules of construction are, because shall means mandatory and may means at their discretion. So, which is not always just something that people know about. Staff misconduct grievances, this type of appeal is submitted to the hiring authority. And so these things really do get looked at when there's also an attachment that you can get that you can actually file on a person at an outside entity for employee misconducts. But not everybody knows about that. And sometimes you have to attach them to the form and sometimes you don't. And if you tear off any parts of the form before you're filing it, then what it does is just make it, they just don't look at it because you've torn off part of the form. And so it's a really complicated system to try to maneuver. And at times they aren't even available. The forms aren't available. So you only have a certain amount of time to appeal an issue that's happened to you. And if you go over that time, then they don't look at it either. There are time constraints for them. If they have 30 days to get you back an answer, oftentimes they will send you a form in the mail asking you for 14 more days. I never gave them any more time because that time that they're using, that 14 days extra that you're giving them, they're oftentimes, unfortunately, they're using it against you. So they're trying to find a way to deny your grievance and haven't been able to do it in that 30-day time period. And when you're moving,
can I ask, so you can choose not to give them those 14 days, like that's an option?
You absolutely can check the box no and send it back to them.
Okay. And then also Eliza in the chat asks if grievances are all made verbally or can they be submitted via paper form? And so can it just be written on any piece of paper? Does it have to be on the actual form?
It has to be on the actual form. Especially to get an appeals number, you'll have an appeals number. And if you do not use the proper form, say that you need to use extra paper, they have things called continuation forms that you must use. And so if you don't write it down, it never happened. So you must write things down. The other thing is if it comes to the time when their time constraints are up, you can move on to the next level and say, you've exceeded your time constraints. I'm going to move on to the next level and go on to the next level, and you staple all that together. So they go over their time constraints all the time. And if you do not move on, they will deny it based on you have abandoned your appeal. So you have to be very, very careful. Yes, Jonas says make photocopies of everything. Oftentimes we don't have access to photocopy machines. So what we have done many, many times is just rewrote it on our own paper and kept exact copies, but handwriting it.
Well, and Johanna, can I ask, so since most of the people on the call are advocates, what kind of support? So, and again, we're not always going to have all of the ins and outs of the process down, but what can an advocate do to support somebody who is navigating the grievance process? Like, what kind of support can we provide? Well,
I happen to know that the Title 15 is our rules and regulations book, and it's online. So in the rules and regulations, there is step-by-step instructions and time constraints. There's all the information in there that you need to give to another person to help them along in the process. So anybody can look it up, anyone can download it and get that information. So it's helpful if a person, say an advocate wants to help this person get through this process, they can definitely look at the Title 15 and let them know what their legal rights are in this, because you must exhaust your legal appeals to be able to file anything in court. You have to be able to show that you've done this.
And can you tell, when you were going through it, were you able to talk to an advocate?
No, I was not. No,
Okay.
I was not. And no one is helpful. Not a single staff member is helpful. They're not going to be.
So again, if we wanted to be helpful, what, so we can send information and resources. What else could we do? Like what kind of emotional support, even photocopies, like would the photocopies help?
Being emotionally supportive during things like this is really important, because unfortunately, the system and the people who work in it do everything they possibly can to make it completely difficult for you to obtain forms, difficult for you to, especially if you are grieving something that they're in charge of. So they're going to do everything they possibly can, search your room, search you, take away things, little creature comforts that you may have in your room that may not be something that could be considered to be contraband, maybe an extra pillow, just anything. They're going to take everything away from you that they possibly can to try to combat this grievance. So they're going to make it really hard on you, hopefully that you drop it. So emotional support going through these things and knowing and telling somebody that it's going to be better in the end once you've completed it, and that they know that if they try these things with you again, that you are going to bring this this issue to light, is very, very helpful. It may not seem like a lot, but I really, really would have wished I would have had somebody to tell me, you know what, I understand what you're going through and I'm right here with you. So we can discuss things and you can vent to me. You can ask me questions. Maybe I can give you ideas. So it's very helpful to have somebody just knowing that person's in your corner. Just like when you came to see me, Edward, I knew you were in my corner, and that just gives you backup, and that just makes you feel, gives you a strength that you wouldn't ordinarily have.
Yeah. And so it's real. I think that we hear it a lot. I hear it a lot. I think a lot of advocates hear it. They say, oh, my room was tossed. They took all of my paperwork. And sometimes it seems hard to believe, like, is that really happening? But yes, so you say that, yes, that does happen.
Oh, it absolutely happens all the time, because after you've turned in your initial grievance, after that, you start the grievance that you follow through with. After that, you tear off the back copy and you have those copies, and every one of those have to be stapled to the very next grievance. And if they take those, it's over. And so, yes, it happens constantly.
Okay, so if you don't have the copy that they gave you, if they take the copy, then
you're
penalized for that.
Yes,
okay.
You cannot move forward. And obviously, after you've done the first grievance, it's been at least 30 days, maybe 45. So if you don't have that paperwork, your time constraints have, gone for you to file on that again. And so you must have those papers, and they destroy them lots of times. I mean, you literally have to pack them on you when you leave your room. And,
so would you suggest if an advocate, for example, is helping somebody through the process, does it make sense for somebody who's incarcerated to send those copies out so that they're kept safe?
Not the copies that you have to attach, but maybe rewrite those copies on paper and send them out to the advocate for safekeeping. That's what I used to do with JDI. I used to handwrite everything out and send them out so there was a copy there in case they took my copies, and which they did many times. So yes, it's very helpful to have those copies. You can't send out the originals because you need them.
Right,
And
okay.
if you mail them back in, they're just going to take them anyways, because they're considered legal mail at that point, and you may not get them back.
Okay. Well, so yeah, we want to leave time for questions and answers at the end. Is there anything else you want to share right now before we move on to Jonas? But we'll definitely have time to come back.
No, I think that's it, and I'll be happy to answer any questions.
Awesome.
Thank you.
Okay. So let's. Oops, sorry. All right. Jonas. No. Is a former Fulbright scholar and survivor of repeated sexual abuse by staff in a New York City jail. Jonas has obtained his paralegal certificate and worked at the Abolitionist Law Center. He recently finished a summer internship with Prisoners Legal Services of New York and is currently pursuing a law degree from Albany Law School. He is the lead plaintiff in a federal class action lawsuit representing 2,500 incarcerated and formerly incarcerated individuals who suffered mental health discrimination by the New York State Department of Corrections. Thank you, Jonas, for being here. And I'll sort of ask you the same question. If you could just walk us through your experience with the grievance process, and then also with the legal system, because I know that you've successfully been able to file lawsuits, and yeah, you just have a lot to share now with your professional experience as well. And I'll just open up the floor and let you go.
Sure thing. You can hear me okay?
Yes.
Okay, great. Thank you for having me. It's really great to be here to talk on this topic that is very important to me. I have to admit, I got quite frustrated hearing Johanna speak, not because of Johanna herself, but because the grievance procedure is such a Byzantine, horrific experience for anybody going through it. But unfortunately, it's a necessity for those who are seeking any form of relief, especially if you're seeking some sort of judicial relief. So it's definitely frustrating to go back, and it's frustrating to speak on this topic too, I'll admit, but it's super important to be able to share this and to understand the importance of it, but also to understand the importance of, as Johanna had touched on, the emotional support that one needs through this daunting experience. When I was incarcerated in New York City in Brooklyn, after I was sexually assaulted, I was called a liar. I was made fun of by corrections officers. It was a correction officer who assaulted me. Officers were saying, well, I should have enjoyed it because I'm gay. Others were saying, well, perhaps he thought your penis was contraband, and contraband is not allowed in this prison, in this jail. And so they would just find ways to mock you and sort of try to, you're already going through the experience of incarceration. You're trying to understand how the grievance procedure works. So they're just trying to get you down at any moment that they can, in any way that they can. And so, for someone who had never been incarcerated before, you get in there and they explain to you what PREA is. They explain to you very minimally what the grievance procedure is, but you don't really quite get it until you're actually going through it. And so, I didn't have any emotional support on the outside. And so when I'm being called a liar, when I'm, on the receiving end of homophobic slurs, and I'm trying to find some sort of relief for the assault that I experienced. And by the way, this correction officer was reassigned to my unit on multiple occasions after I filed my grievance, and I heard nothing back. I mean, I had a visit from the internal affairs. They interviewed me in a public area in the kitchen area on my unit. And so I wasn't quite in a private area to talk about my experience. And so I thought, oh, well, I have this quasi-independent agency coming in to interview me. I'm doing everything that I was told I need to do. I've submitted my grievance. I told my story. I'm just gonna wait and someone's gonna come and rescue me, right? No, that 100% was not my experience. In New York, in New York City, they there's 60 days that they're supposed to investigate a claim of sexual assault under the New York City PREA standards. I think the national PREA is 90 days. But in any case, that was not my experience. It actually was nearly 500 days before they totally, fully investigated my claim, which they ultimately said was unsubstantiated because one of the investigators failed to retain video evidence of the assault. And so I was alone. I didn't have any law background at the time. I didn't know what the hell was going on. Nobody was believing me. I was being called a liar. I was being called, a faggot and things like this. And so I had to delve into like some prison law studies because I had no one to turn to. And so I was reading books in the law library. I was trying to figure out how can I find someone to actually advocate on my behalf. And instead I had to learn how to become an advocate for myself. But, I was sending letters to elected officials. I was sending letters to international and national organizations. And it was months before I finally landed on JDI, which, kept correspondence with me and were able to provide resources for me. And that's how I found the Crime Victims Treatment Center and an advocate through CVTC named Rachel, who was amazing and who I still speak with to this day. And so I think I was very depressed, by the way, during this whole experience. And there's nowhere to talk privately. So, you're just like, you can't really communicate on the phone with your loved ones. But when I found Rachel, I was able to have a private room where I could discuss these matters with her without the fear of having people hear me and listen in. I was already dealing with enough as it was to have the whole world know, my emotional and mental distress. But in any case, back to the grievance issue, I, as Edward said, I was successful in a couple pro se lawsuits in the Eastern District of New York. And the Eastern District is a federal court. And in order to succeed, and Johanna kind of touched on this a little bit too, is that in order for someone to succeed in a lawsuit in federal district court, you need to exhaust the grievance procedure all the way through every single level of the grievance procedure. And you don't quite know this going into it. I guess I said that the grievance procedure was the bane of my existence, but so was the Prison Litigation Reform Act, which mandates that you exhaust the grievance procedure all the way through to the highest level. If you don't, you're going to lose your lawsuit. And so you make one mistake here, you make one mistake there, you're just not going to win that lawsuit. And so when you throw someone into the grievance program, which I don't even like to call it a program, it's like it's designed specifically to make you fail. The Prison Litigation Reform Act is designed to make you fail. It's there in order to prevent. I mean, they don't try to hide it. Like it exists so that incarcerated people cannot win a lawsuit, and that's basically the gist of it. And so when you're new to incarceration, or you're back at it, or you're repeatedly victimized while you're incarcerated, and you're being told that you have to submit a grievance, and you're not getting a response to the grievance, and then you're appealing that grievance, and that grievance is not being responded to, you lose faith in all of that. And so and I didn't know I was going to be submitting a lawsuit at the end of all this. I just wanted this guy out of my unit. I wanted my voice to be heard. I wanted to be vindicated. I wanted people to hear me. I wanted to stop this from happening to myself again or to other people. So I didn't quite know that ultimately I was going to become a pro se litigant. I didn't even know what the hell that meant at the time. I just was like, I'm going to just submit this lawsuit and see what happens. And the lawsuit I submitted was handwritten because I didn't have access to a typewriter at the time. I later did, but that's another story. But in any case, the question they're going to ask is, did you exhaust your grievance? And like I said, if you didn't exhaust it, you're going to fail at winning a lawsuit. And so, I did successfully end up settling that suit. because it was clear that I had exhausted the grievance procedure, despite the fact that the counsel for New York City was trying to argue that I did not, the federal district court basically said, well, you guys aren't responding to his grievances. So there is no existing grievance program for this guy to actually utilize because you're not responding to him. And so I was able to secure the civil rights clinic from a university in New York to represent me in settlement discussions. Edward, I see your hand is up.
Yeah, we have a question in the chat. And I actually was wondering the same thing. Eliza asks if grievances are separate from PREA reports. And I was also thinking, like, is it the same to file a complaint? Like, are those things interchangeable?
So I'm speaking from a Pennsylvania and New York experience. And so I can't say 100% about California, but I can say that in order to file a PREA grievance in New York, yes, you should file a grievance. And I think California, I was reading through the prison law office resources, which is amazing, by the way. Like, that's a really good job with that. But I see that on the website, there are different forms in California in order to file a PREA, a sexual assault grievance. I don't know if you call it a PREA grievance or what, but in Pennsylvania and New York, they're basically the same thing. And there's no time limit. And I think it's the same in California, that if you are the victim of a sexual assault, you don't have 2 weeks or whatever it is to submit a grievance. You file it whenever you can or whenever you.
Yeah, I think the rules are a little different in that I think it could also just be made verbally or
Right. Yeah, and you can make a
piece of
verbal
paper.
one in New York and Pennsylvania too. But again, as Joanna said, that one of the key things about filing the grievance is to document it. And so whether or not you're going to like completely exhaust it or not, it creates a record both within the Department of Corrections and within your own for your own files, in order to be able to show that you advocated for yourself, that you took certain steps in order to resolve the issue, and that a timeline was created. And so I think that's important with regard to like statutes of limitations and things like that. So yeah, does that answer your question?
Yeah. And can I also ask, you said that it was 500 days from when you were first interviewed, so you got some sort of a response?
Yeah, so it was 500 days, not from when I first was interviewed, but when I submitted my grievance.
Okay.
I submitted my grievance the day after the assault happened, maybe even the day of, I can't remember. But I was interviewed within a couple days by the internal affairs people. And then I got a denial at one point, and then I appealed that to the next highest level. And then I got another denial. And then I was already out of prison it was during the pandemic. I was released in December of 2019. And about maybe 8 months after I got out, I received a final disposition to my grievance stating that my claim was unsubstantiated partly because the video evidence was not retained.
Yeah.
But it was also, they saw that I had already settled a lawsuit against them, and they also called the issue moot because I was already out of prison. And so they had all kinds of excuses, as the Department of Corrections typically does, for to disclaim any abuse that they have caused. And then the abuse, like, it continued. I was retaliated against. Johanna touched on this. A lot of people are hesitant to file a grievance because they're afraid of retaliation, which, yes, is a very real thing. After I was transferred from New York City Department of Corrections to the New York State Department of Corrections, I was threatened with them to come in, and I lived in a dorm, and they said if I did not withdraw my grievance, they were going to come in, flip everybody's cell, and blame it on me, and say that this is what the captain, which is like the step below the superintendent or the warden of the prison, he literally told me to my face, if I don't withdraw this grievance, he's going to do this, blame it on me because I told on everybody for having drugs or whatever it was. And so it wasn't a sexual assault grievance, but I was forced to forced to withdraw it because I didn't want to get beat up in prison,
Yeah.
And so those things are real, and people, that's why it's important, I think, to have an emotional support person on your side during all of this, because not only are you faced with these obstacles, not only are you not being heard, not only are you being called names, but you're being threatened with serious repercussions if you continue to try to advocate for yourself. And so having someone to talk you through these trying times, like Rachel was a godsend for me. And I think I wish I had known about JDI sooner, and I wish I had known about Crime Victims Treatment Center through JDI sooner, because I would have had Rachel on my side at a much sooner time. And I had never spoken to a therapist or a social worker in that kind of way before. And I see a therapist now because it's so helpful in order to continue. There's still residual stuff that I deal with every day. I still have a lawsuit that's going on now that I sat for a deposition a couple of months ago, and it was very antagonistic, and he was trying to, this is a lawyer for the state trying to, he was in a roundabout way calling me a fabricator, right? And so to be able to speak with somebody about all of these things, to reaffirm you, to like let you know that you're not alone, to hear you, is really important. And so I guess that's the point I'm trying to make here. Like, yes, the grievance system sucks. The Prison Litigation Reform Act is horrific, but to end on a positive note, I think to have the point I'm trying to drive home is to get there early and to be consistent, and to be, I don't know what access is like to incarcerated people out there in California who are going through sexual assault or who are survivors of it, but just to be able to be there and be consistent is really important.
Awesome. Thank you, Jonas. Yeah, I think we hear a lot from people during, Marcus, the 500 days seems really excessive. But I think that's when we hear from people, is during that time period when they haven't heard anything. And it's really hard to know what to say or what kind of support to provide, other than like, be patient, like,
Right.
So is there anything, what could we say to somebody who is in that waiting period where they haven't heard anything, they don't know what's going on, what the, where the investigation is?
Right. Well, I mean, I guess I know that it's touchy to be able to provide legal advice. Like, it's because I guess most of the folks on here on the call are maybe not attorneys or not legal advisors or whatnot, but there are resources that help me out tremendously that I found through the grapevine. You're out in California, so the prison law office website is, I mean, I'm going to admit I only started looking over it today, but I was like floored by the conciseness of the information and the process. And I learned a lot just, in the hour or so that I looked over that. So to be able to provide something like that, I don't know if there's a printable version of that. But I think, but also the Jailhouse Lawyer's Manual, it was like my Bible on the inside. The Jailhouse Lawyer's Manual is put out by Columbia University, and there are chapters in there. You can download it, you can print it, you can send it to incarcerated people. And the chapters deal with everything from like sexual assaults to, First Amendment issues, religious rights, the fact that you're being denied legal mail, things like this. You can select whatever chapter you want. You can download the chapter on how to file a Section 1983 federal lawsuit, which, it's burdensome and it's scary. And dropping that lawsuit in the mail, I was like, nothing's ever going to come of this. It's a handwritten lawsuit going to federal court. But no, like, it'll get to where it needs to go. And those resources really were helpful for me being in there. But ultimately, just being able to hear the person out and asking them what it is that they need the most, maybe taking that extra step to contact somebody else on their behalf that they're asking about. Maybe they're asking for an address of an elected official, a congressperson, a senator, a state or a city council person. Like Rachel got some of those names and contact numbers for me, because she worked closely with a lot of the people in like the New York City Human Rights Council and things like that. So just being able to listen, to hear them out, maybe take that extra step if you can, send resources if they're asking. That's what I would suggest.
Awesome. Thank you, Jonas. Yeah, so Marcela shared some resources in the chat. We'll also put those together in an email or a Dropbox type thing or something. And we definitely recommend, if you can, if you have the resources, to create maybe a packet. JDI sends out a packet of information that includes several chapters of the Jailhouse Lawyers Manual. It's long, so if you can like narrow down what the survivor is asking for to the relevant chapters and send those out, you know, they're like 12 to 15 pages long, the chapters, so that seems manageable. So creating a packet that can be shared with people, I think could be helpful. But yeah, so we have some time for some questions. We'd love to open it up and hear, yeah, what y'all are thinking or what your questions are.
I just wanted to say, first of all, thank you both so much for sharing your stories. It's definitely hard to hear that the grievance process is that difficult. I have had clients tell me that things got nowhere and it didn't make any sense. So while it's hard to hear about, it's really important to see just how long it took for any of you to have any kind of response. Shifting to more of a California mindset with PREA and reporting, I just want to check in either if the panelists know the answer or anyone from Valor or JDI or anyone here. Typically for the correctional facility that I work at, when a client of mine does submit a PREA report either through me, I can report on their behalf. Detectives from the sheriff's office follow up on the incident. And when my client wants to hear how it's going, I'll typically follow up with the people that they reported to initially. And that can get hard if I can't get a release of information. But what will usually happen is I'll suggest they submit an inmate request form to get in touch with the detective assigned. But I was just wondering if anyone knew of any other ways that we in California can follow up directly to get information, because oftentimes when I call the detectives, they say they can't share the information with me. And I'm not sure if that's true, if my client would give the go-ahead for them to communicate with me. If my question doesn't make sense, please tell me and I'll try to rephrase it.
I think that makes a lot of sense. And I think that your client should be able to give you a release to get that information. That's really interesting in that when I was sexually assaulted while incarcerated in Chowchilla, and they shipped me before I was able to speak to law enforcement. So that is a really big deal that I would like to touch on for a second. Anyone who's been sexually assaulted should be able to speak to law enforcement themselves. The person who is the actual victim should always be able to make a report to the sheriff's department in that jurisdiction. In my case, they shipped me out and made the report for me, and it was a false report. And so I think you should be able to definitely get permission from your client, written permission somehow. Maybe they can get it notarized if they have a notary in that institution, and usually there are notaries in the institution. Get a notarized, some kind of letter giving you permission to get those reports. They're very hard to get. I couldn't hardly get my own report, so they're very hard to get.
I'm thinking, I mean, there's like some pretty glaring like legal parameters to how you could access that. I'm just thinking like at Prisoners Legal Services, even to communicate on behalf of our clients about like whether they were in solitary confinement or what unit they were in, or whether their disciplinary sanctions had been dismissed or whatever it might be. We had to have each and every client sign a release form, and which the prison would keep on file. And so when we would call things like the Office of Special Housing, or even just the operator at the prison to ask if they were there, they would look at that release form in order to communicate, to answer our questions. So for something as serious as a sexual assault in private, as a sexual assault issue, I would imagine there'd be some sort of almost like a HIPAA-like form in order to be able to communicate those kind of issues. So I don't know if you have a legal beagle out there that could help in drafting that or researching something like that.
So I think following this discussion, just in general, I'm going to start some talks with the sergeants I do communicate with at the correctional facility, because so I work for Verity in Sonoma County, and we have a pretty good relationship with one of the sergeants and one of the lieutenants. And since the correctional facility is staffed by the Sonoma County Sheriff's Office, they have a pretty clear understanding of how grievances and the PREA reporting go. But after both of your presentations and your answers to our questions, I definitely feel like I'm more prepared to start that conversation with some of the staff in the jail. So thank you.
And I will say, give a quick shout out. I mean, it seems like you're getting more information than most of us would get. And I think that talks to the relationships that you have. Like when advocates have strong relationships with staff members at the facilities that you're working with, it makes it so much easier, right? Like they trust you. So when you come to them, they're much more willing to be helpful. So even just saying, my client has said that they haven't heard anything back, can you please be sure to follow up with them? That way you're not getting the information yourself directly, but you're informing them that, you know, they need to follow up with the survivor directly. Jonas?
Yeah, on that note, I think that's extremely important. Like a little piece of me dies every time I'm nice to somebody in the Department of Corrections, but it's super important to keep those relationships up on some level that's heightened, because I had some really good successes in my day, even as a formerly incarcerated person, both as a paralegal for the Abolitionist Law Center and then now as the legal intern for Prisoner Legal Services. For some reason, like when you're nice to them, they'll, not all the time, but a lot of them will be very nice back. And so a lot of the staff attorneys at PLS were like, how are you getting a response from Taylor? Like, well, she never responds to us. And I'm like, well, because I'm nice to her. Like, I hate that, like, she's doing a job. She's there, like, getting a paycheck. You know, she might even hate her job. Who knows? But like, you say good morning and you just communicate to her like she's a human being. And you might actually get, like, I was working on an appeal for someone had a solitary confinement sanction of 700 days. And I was trying to transcribe the audio hearing for his disciplinary hearing. And we had a deadline coming up to submit our appeal. And one of the important part of the audio tape was missing. And so I just called up Taylor and very nicely asked her how her day was, how was her weekend. It was the July 4th weekend. I hope you had a good time, blah, blah, blah. And she overnighted for free the missing audio tape so that I could transcribe it and then submit this appeal, which we're still waiting to hear back on. But I don't know, I'm just trying to say, you be nice and you might just get what you need to get. And it sounds like, I don't know who was speaking, but it sounds like you have that already going. So kudos to that.
Yeah, thank you, Jonas.
I have the advocates who were before me in this role to thank, for sure. It does make it a lot easier to get my clients what they most need. The facility I work in, following a PREA report, they always get medical attention and mental health to see my clients. But I remember one time, and it kind of reminded me of part of your story, Jonas, where mental health went to follow up and they did it publicly. Where if my client were to actually talk to them, other people in the neighboring cells would have heard. One of the people in the neighboring cells was a family member of the alleged perpetrator. So being able to call the sergeant I have a great relationship with and say, hey, like, can mental health go again, but can they be in an interview room or even a PNC visit where there's privacy? And it's just great to be able to work with someone at the facility who cares so much as well.
Oops, shoot. So we are almost out of time. But I'm going to get through these resources really quick, and then hopefully we have time for another question if people want to stay on. I don't know if Johanna and Jonas, if you have a couple of minutes. But as Jonas mentioned, the Jailhouse Lawyers Manual, I think is really helpful. These are a few of the chapters that might be particularly relevant for people. The inmate grievances, right to medical care, right to be free from assault, illegal body searches, which is a big thing that comes up a lot. Marcela shared the website where you could download all of the individual chapters. We'll also provide links. And then there's also the prison legal office document that Jonas had also mentioned. And that also outlines the whole process in California. It is really succinct and thorough. So that's another really valuable resource. If y'all want to just sort of familiarize yourselves with the process, or it's also something that would be helpful to send to people who have questions. As always,
can I say something real quick about the illegal body searches? That's a very big issue in New York and Pennsylvania, probably I'm assuming in California too. I recently represented myself in a Fourth Amendment illegal body search case in New York in state court, and I won. I still have to go back in October to see how much they owe me. But if anybody has any questions, I put my email in the chat, especially with regard to like body search issues. Let me know. And you know, it's a topic I feel very strongly about and I'm very passionate about.
Yes, thank you. So as always, we have our websites here. You can email any of us, Marcela, Jenica, or I. And that's all I have. Marcela, do you have anything before we wrap up?
One last thing, I do have a survey for folks to fill out and give us any feedback. Or if you think of any questions, feel free to drop those in the survey too, but obviously getting us those questions via email would be best. So please do provide us with some feedback. Thank you.
And I mean, I think we're willing to stay on a couple minutes, right? If anybody has a burning question. Otherwise, thank you all so much for being here. The time really did go too quick.
Thank you again.
Thank you.
Thank you.
I just saw something drop in the chat.
Help me help you.
Should I read this out loud or do you?
Help me.
Yeah, go for it.
Okay, so I'm not sure how relevant this is, but in the past I've worked with non-PREA clients and together have called and left a voicemail with a reporting detective where the client has given verbal consent stating there's name and providing my name as a contact for the detective to release personal information. I can imagine using one's personal phone to call law enforcement while the client is on the client line just to get out around the confidentiality piece. That's helpful. I think this, but unrelated to incarcerated folks. Thank you, Billy. And I think I saw Kimberly, you were going to ask a question potentially because you unmuted yourself. So feel free if you do.
I was just asking if you all think it's better to file the PREA report electronically or via the paper form.
I can't speak to that because I'm not sure how the tablet system works in California. I don't trust electronic things because I never know who's reading on the other end. I mean, same could be said for paper too, I guess, but I don't know. I don't know. I would go paper, but y'all in California probably know better than me.
The tablets are definitely monitored, so any communication that takes place over the tablets is being read. Obviously, yes, I think that's the same with the paper. Like, it could potentially fall into anybody's hands. But
even on doesn't the tablet have the different types of grievances? And so if it was a sexual assault grievance, would that be monitored too?
Well, here's the thing. Oftentimes they say they aren't, but as long as you have, the tablets are all monitored. I'm just going to say that they're all monitored by everybody. And after a certain, a sergeant and above can read anything on those tablets. So, and the biggest problem in prisons are staff are not confidential. So they tell everything about everybody. And the other thing is with that is if you just file that on a tablet or electronically, then you don't have anything physically to prove that you did it.
Yeah.
And so if you're going to file it electronically, I would also keep a paper copy, because anything is subject to happen to those tablets. They're not very well made. They're cheap. And if you drop it, it's over. And so, and then that information goes off into the JPay land or GTL land or whatever, who is another group of people who read everything that gets processed through your tablet. So.
also, I mean, some people are getting more comfortable with the tablets and that's their preferred method of communication. So obviously, if that's what they feel comfortable with, I would say they should submit it that way. But
can I add two important things I forgot, and for the folks on this call who've remained, maybe this will stick or something, but keeping, and I did mention keeping copies or making photocopies, and I understand California, it might be hard to do that. But like some of my lawsuits, I actually, had I not kept those copies, I couldn't have introduced those things as evidence because the prison somehow managed to be missing important grievances or appeals that I had submitted. And I had physical like photocopies of that stuff, which I was able to introduce as evidence in some of my cases. And then with regard to having an advocate on the outside, I don't know if folks keep notes during conversations with people who have been assaulted, but my advocate was able to actually submit a PREA report on my behalf in order to show that I like to prove emotional damages. It was really like instrumental in one of my cases. And so I don't know if that's policy or whatever for folks who are advocates, but to take if that is policy, to keep concrete notes about how someone's being impacted, it might actually help in litigation if somebody ends up taking it that far.
well, thank you guys so much, Johanna and Jonas, and everybody else as well. Do we have any other quick questions? Okay, well, feel free to reach out to any of us. We'll follow up with the resources. And yeah, you wanted to say something else, Jonas?
No, I was just gonna thank everyone for being here and having me and listening.
Thank you. I know you're busy and you've got a lot going on, both of you. So
Thank you so
appreciate
much, everybody. Thank you, Jonas, for always being there.
And you too, Johanna. Always lovely seeing you.
You too, Edward.
All right, you
Everyone
too.
have a wonderful evening.
All right.
Thanks,
Talk soon,
everyone.
everybody.
Bye-bye.
Bye.